Hi, I am attorney Chris Bathan-lasco. This is my virtual classroom. Welcome to my YouTube channel. In this channel, I shall aim to simplify the law. I will discuss concepts and principles of law in under 10 minutes. And I'm going to talk about void or inexistent contract. So this is the fourth defective contract. So let us start. So what are the characteristics of your void or inexistent contract? So, of course, when you say inexistent, that means it is inexistent from the very beginning. Okay? So it's void from the very beginning. Second, it produces no effect whatsoever. Why? Because it does not exist. So there are no effects whatsoever. Third is it cannot be ratified. Why? Because you cannot ratify what does not exist. So these are the three characteristics. Again, void or inexistent from the very beginning. It does not have any effect or it produces no effects whatsoever. And lastly, it cannot be ratified. Now, there are several kinds of void or inexistent contracts, and you have that under Article 1409. So first, those whose cause, object, or purpose is contrary to law, morals, good customs, public order, or public policy. An object and your cause, they're practically the same, only that you look at it at a different perspective. So it is an object in whose perspective, the one giving that thing up. And the cause is the thing that you are expecting to receive in return. So for example, if I will sell a particular ring for, let's say, 100,000 pesos. So in my perspective, the object is what I am giving. And that is the ring. And my cause is that one which I am expecting in return. And that is the price of 100,000 pesos. But in the perspective of my buyer, his object is the money that he is going to pay me, while his cost is the rate, meaning the object that he is expecting to receive from me. So if the object or the cost is contrary to law, morals, okay, or public policy or public order, then it is as if there is no object or there is no cause. Why? Because what makes up a contract? There are three elements of a contract, and that is your consent, object, and your cause. So if the object or the cause is illegal, then the law deems it as if it does not exist, and therefore there is no object, there is no cause. And what happens to the contract? It does not exist. It is void from the very beginning because it lacks an essential element. Second, those which are absolutely simulated or fictitious. Why are absolutely simulated contracts void? Because of the lack of consent. Why is there lack of consent? There's really no intention to be bound at all. And so there is no consent. So again, one missing element of a contract, consent. Therefore, such contract does not exist. It's a void contract. Third, of course, the same discussion is that with number one. Those whose cause or object did not exist at the time of the transaction. So, if at the time of the transaction, there was in fact no object or no cause at the time it was perfected, then it is also void. Fourth, those whose object is outside the commerce of men. So if the object is the sun, the moon, and the stars, clearly that cannot be an object of a contract. And so the law deems it as if there is no object. So again, a lacking essential element, therefore the contract is void. Fifth, those which contemplate an impossible service. Again, when you say impossible, that does not only mean physical impossibility, but also illegal impossibility, or even impracticability, meaning beyond the contemplation of the party. If it is an impossible service, then whether it's physical impossibility, legal impossibility, or moral impossibility, then it also makes a contract void. 6. Those where the intention of the parties relative to the principal object of the contract cannot be asserted. Why? Because the object, you're not sure of what it is. And so, the law will consider that as the parties having no object in the contract. So, no object, lacking an essential element, and so therefore the contract is void. And of course, those expressly prohibited or declared void by law. Again, we mentioned the essential, or rather the one of the characteristics of a void contract, that it cannot be ratified. So the last paragraph of 1409 tells you that these contracts cannot be ratified. Neither can the right to set up the defense of illegality be waived. Okay? Now, for void contracts, okay, whose cause, object, or purpose is contrary to law, morals, the custom, public order, or public policy. You can further classify them as either an act that constitutes a criminal offense or an act that does not constitute a criminal offense. Because while your object or your cause may be considered inexistent, it does not necessarily mean that the act is criminal or that it constitutes a criminal offense. So in 1411, that covers those acts constituting a criminal offense or contracts entered into constituting a criminal offense. And it gives you the consequences of such contracts. So it says here, when the nullity proceeds from the illegality of the cause or object of the contract, and the act constitutes a criminal offense, both parties being in pari delicto, they shall have no action against each other, and both shall be prosecuted. So here you are introduced the concept of in pari delicto, meaning both are at fault. And because both are at fault, then you cannot ask help from the courts. You will be left as you are. But of course, in that same article, it tells you that the proceeds of such contract will be confiscated in favor of the state. And also, since the act constitutes a crime or a criminal offense, then both parties will be prosecuted. But neither party can sue each other. Okay? And it further states, moreover, the provisions of the penal code relative to the disposal of effects or instruments of a crime shall be applicable to the things or the price of the contract. And this rule shall be applicable when only one of the parties is guilty, but the innocent one may claim what he has given and shall not be bound to comply with his promise. In other words, if both parties are guilty, you cannot get back whatever you may have given by virtue of this illegal contract constituting a criminal offense. But if only one party is guilty and the other is innocent, the innocent party may recover. Again, it will be up to the discretion of the court. Okay? Now, how about for contracts which are considered unlawful but does not necessarily constitute a criminal offense? Okay? So that's 1412. It says, if the act in which the unlawful or forbidden clause consists does not constitute a criminal offense, the following rules shall be observed. First, when the fault is on the part of both contracting parties, neither may recover what he has given by virtue of the contract or demand the performance of the other's undertaking. So again, you cannot recover from either of you because both are at fault. And it is an unlawful contract. It's an illegal contract, although it may not be a crime or it may not be a criminal act. Second, when only one of the contracting parties is at fault, he cannot recover what he has given by reason of the contract or ask for the fulfillment of what has been promised him. The author who is not at fault may demand the return of what he has given without any obligation to comply with his promise. So here, the second paragraph tells you that tells you of what would be the consequences if only one is at fault. If one is at fault, then of course he cannot recover, and the one who was innocent can recover if he has already given something by virtue of that unlawful contract. And if he has not given anything yet, then he cannot be obliged to comply with whatever he may have promised under such contract. Now, 1413, it says there that interest paid in excess of the interest allowed by the usury laws. Now, remember that the usury laws have been already suspended. So, basically the limit on interest now is the conscience of the lender. And of course, that does not mean, however, that if you will be victimized by unscrupulous lenders, that you do not have a remedy. Of course, you can ask the courts to lower the interest, of course, with the reason that the interest is unconscionable or shocking to the conscience of man. But usury losses of the moment that is suspended. Okay? 1414. It says there, when money is paid or property delivered for an illegal purpose, the contract may be repudiated by one of the parties before the purpose has been accomplished or before any damage has been caused to a third person. In such case, the courts may, in other words, it depends upon the discretion of the court. The courts may, if the public interest will thus be subserved, allow the party repudiating the contract to recover the money or the property. In other words, the recovery of the money or the property depends upon whether the purpose has not yet been accomplished or if damage has not yet been caused to a third person. So, for example, A hires B to kill X, and A promises B a reward of 1 million pesos for killing X. But he advanced that money to B. So B has not yet killed X. This provision under 1414 tells you that A is allowed to recover the money, again, by the discretion of the court, if the court will allow it, to recover the money so long as the purpose has not yet been accomplished, meaning B has not yet killed X or no damage has yet been suffered by a third person. But again, of course, it depends upon the discretion of the court if the court will allow such recovery. And the basis for allowing is if the court believes that public interest will be served by allowing such return. Now, what happens if one of the parties to an illegal contract is incapacitated to give consent? Can the incapacitated person recover whatever he has given by virtue of the illegal contract? That's 1415. The law says, where one of the parties to an illegal contract is incapable of giving consent, the courts may, if the interest or justice so demands, allow recovery of money or property delivered by the incapacitated person. So again, it will depend upon the court. All right. Now, 1416, okay, speaks of agreements that are not illegal per se, but prohibited. Okay? 1416 says, when the agreement is not illegal per se, but is merely prohibited, and the prohibition by the law is designated for the protection of the plaintiff, he may, if public policy is thereby enhanced, recover what he has paid or delivered. If you can observe, with 1416, 1416, and 1414, recovery is allowed. But the underlying reason for allowing such recovery is public interest. So the courts will decide as to whether to allow recovery. That is, again, if public interest will be subserved by such recovery. Now, what is an example of something that is not illegal per se but prohibited? An example would be um, A donating everything that he owns to X. If you can still remember, under your family code, there is a mention there, just a discussion that if you do donate something, you must make sure to leave enough to support yourself and to to support those who you are legally obliged to get support. So if you donate everything that you have, it may not be illegal per se, but it is prohibited to protect you also. You are protected because you are to leave something for your support and for the support of those whom you are legally obliged to give support. So if you give everything, okay, so he donated everything he owns to me. Is A allowed to recover? Supposing he has no more money to feed himself, can he recover? The law allows it only to the extent that he may need to support himself and to support those who he is legally obliged to give support. Okay? Now you read the case Philippine Banking Corporation versus Liu Xie that talks about there was a lease of a certain property, but in the contract, it was not merely a lease, but the alien who was renting it was given an option to buy a piece of that property. Now, the Supreme Court said this is a circumvention of the Constitution because the Constitution does not allow aliens to own lands in the Philippines. There are only certain exceptions, which I'm sure you have learned in your constitutional law. But in this case, it did not fall under the exceptions. So the question now is, will the heirs of that person who entered into a contract with the alien, okay, in the contract of lease and with an option to buy, can the heirs recover the property? Because the contract said there that there's a lease and that there's an option to buy. And the Supreme Court said this is basically letting the alien own the property. So the Supreme Court said that yes, although the original parties to the contract were both guilty for entering into such an illegal contract, they're in pari delicto, and the general rule is if you are in pari delicto, then you will be left as you are. The courts will not aid you. That's the general rule. The Supreme Court said this is an exception because if they were to do that, then they are now allowing idiots to own lands in the Philippines. And public interest will not be served by doing so. So, just like what we mentioned earlier, recovery may be allowed if public interest is self-serve. And here, it is to protect the Filipino owner. And so, in this case, the Supreme Court ordered the return of the property from the alien to the heirs of the original lessor. Another case, the case of Frenzel versus Gatito, if you can remember, this is the love story between an Australian man and a Filipino woman. The Australian man bought a property, but of course, knowing fully well that the property cannot be named after him, the deed cannot be in his name rather, he put it under the name of the woman. So now he wanted to get the property back, saying that it was really my money. That woman, that Filipina could not afford to buy that property. But what did the Supreme Court say? The Supreme Court said, I'm sorry, but you are not allowed to buy properties in the Philippines. You know fully well that you cannot do so. You entered into an illegal contract, and so you will be left as you are. You cannot ask aid from the courts because if you were allow recovery, then it will not serve public interest because even if that's your money and if the courts will allow the property to be given to you, then we are now running afoul the constitutional prohibition that aliens cannot own lands in the Philippines. 1417. When the price of any article or commodity is determined by statute or by authority of law, any person paying any amount in excess of the maximum price allowed may recover such excess. Now, why is this under void contracts? Basically, what this article is telling you that the excess that you paid is void and that can be returned. In fact, already have this in the Consumer Act, where overpricing is not allowed. So, if you bought surgical masks, if you bought N95 masks or thermometers, infrared thermometers, and they are overpriced, you can actually recover the excess. Of course, you have to go through the proper authorities. So you have to inform DTI about it so that DTI can start looking after these unscrupulous entrepreneurs. So this is what 1417 is all about. 1418. This, in fact, you will cover this under your labor law or your labor code of the Philippines. It just tells you that when the law fixes or authorizes the fixing of the maximum number of hours of labor, and a contract is entered into whereby a laborer undertakes to work longer than the maximum thus fixed, he may demand additional compensation. In fact, that's why for those of you who are working, if you exceed the number of hours, you are being paid overtime pay. If you work during a holiday, then you are also entitled to holiday pay. So even if you enter into a contract and then you allow your employer to not give you overtime, that is void because that is not allowed by law. So you are by law entitled to your overtime pay. Of course, there are exceptions to that. Like when you're a manager, so you are a managerial employee, then there is no overtime. So these are only for rank and file. You will learn more about that under your labor code. 1419, when the law sets or authorizes the setting of a minimum wage for laborers, again, labor law, and a contract is agreed upon by which a laborer accepts a lower wage, he shall be entitled to recover the deficiency. Now, when you study your labor law, you will be introduced by the fact that there are different minimum wages for different types of cities. So the minimum wage in Cebu City is different from the minimum wage in NCR. The minimum wage in Mandaue City is different from the minimum wage in, let's say, Bajan or in Toledo. Okay? So there are different minimum wages, but you have to look at the advisory for that. Now, what if you are employed and your employer gives you a contract of employment, then it says there that you will be receiving less than the minimum wage. Okay? And then you badly needed the work. So you said, okay, I'll just be okay with this daily wage or this pay, despite the fact that this is much below the minimum wage. And so you sign the contract. Can you still file an action against your employer to recover the deficiency? Deficiency meaning the amount that you're getting versus the amount that you should have been getting if it were the minimum wage. The answer is yes. Because you cannot bargain away what is given to you by law. The law entitles you to a minimum wage. So even if you enter into a contract and agree that you will be paid less than the minimum wage, still you can recover the deficiency. That is 1419. 1420. In case of a divisible contract, if the illegal terms can be separated from the legal ones, the latter may be enforced. So if it's divisible, then only that part which is illegal may be declared as void, the rest of the contract can be enforced. 1421, the defense of illegality of contract is not available to third persons, meaning third persons cannot file a case in court to ask that the contract be declared as null and void. Why? Because you're not party to the contract. Only those party to this illegal contract can file such case. This is not available to third persons whose interests are not directly affected. 1422, a contract which is the direct result of a previous illegal contract is also void and inexistent. Why? Because the spring cannot rise higher than its source. If the source is illegal, then all the other contracts springing from that illegal contract will also be considered as illegal or void. What is the prescriptive period for filing an action to have a contract declared as null and void? 1410 says it does not prescribe. It is imprescriptible. Why? Because it does not exist. So at any time, you can ask the court to declare it as null and void. So that ends your fourth defective contracts, your void contract. So if you find this video helpful, please click like, subscribe, and that notification bell so that you will be notified of new video uploads. Thank you for watching. See you next time in MBL Classroom.